Can I get 4 years in prison for failing to appear for one court date on a DUI or other criminal offense? I'm Gordon Thompson, DUI and criminal attorney for 46 years. Failure to appear for a court date on a DUI or other criminal offense is a crime. If the offense is a misdemeanor, then the failure to appear is a misdemeanor, and if it's a felony, it's a Class 5 felony. Arizona can be very harsh on DUI and criminal offenses, as a defendant in a rural county recently found out in the case of State versus Tafoya. That defendant was personally served with a summons to appear at an arraignment on a felony charge. The defendant failed to appear, and the court issued a warrant. That very same day, the county attorney filed a separate felony failure to appear charge. The county attorney also filed an allegation of prior convictions, saying that the defendant had at least 2 prior felony convictions. The effect of that filing was to make probation not available in the event that it was guilty and to make prison mandatory. The county attorney was not required to file that allegation. 1 week later, a police officer arrested the defendant. The failure to appear charge went to trial, and the jury returned a guilty verdict. The court then sentenced the defendant to the mandatory minimum sentence for a Class 5 felony with 2 prior convictions, namely 4 years in prison. It is important to note that the defendant was convicted and sentenced to 4 years in prison for the act of not appearing at exactly one court date. The court date was for a preliminary matter, namely an arraignment, and not something more serious, such as a jury trial. It would have been easy to simply find and arrest the defendant on the original charges and hold him in custody until trial. The defendant had been personally served with a summons, and so the police had some idea where he was located, and in fact, he was arrested only 1 week later. It is also important to note that this 4-year prison sentence will cost the Arizona taxpayers over $150,000 to incarcerate him. That cost would have been zero if the allegation of priors had not been filed and probation was available, and that was the sentence. Lastly, from public records, it appears that the defendant was found not guilty of the more serious of the original charges.